Good evening, ladies and gentlemen. My name is Mark Ryan, and I would like to welcome you to an evening of civil discourse. Stressing the civil discourse. I am the current chair of the Human Rights Commission, and we are one of the sponsoring agents of this particular activity. We have a very, very interesting topic to discuss, and obviously a fair amount of interest. What we do not have is a lot of time. So I am going to ask people to keep their input, their discussions to approximately 5 minutes. If you could, I'm not going to hold a timer up and bang a gavel, but if you're speaking for 15 minutes, I am going to stand up and ask you to sit down. The more people we can get engaged in this conversation, the better this conversation is going to be, right? So please respect others, other individuals' opportunity to participate in this forum. Right? And I would like to introduce Michelle Lisey, the Red Wing Community Engagement Specialist, who will introduce our speaker.
Thanks, everybody. So this is about free speech, so yes, you will be able to speak, and you can speak freely. So have no concerns about that. We are very happy that Jocelyn Poehler is here today. She is a lawyer from the Southern Minnesota Regional Legal Services. Did I say that? That is a mouthful. And Jocelyn contacted us because she has, their group has a grant from Blue Cross Blue Shield to work with human rights commissions and to go throughout Southern Minnesota and have discussions on free speech. And so Jocelyn is here to sort of lay out what free speech is and to start the conversation, and then we will open it up to questions and discussion. I do know that 60 minutes is not very long, but we hope that we'll be able to have a robust conversation regardless. And then we welcome everybody after 7:30. We'll end the meeting, but you're more than welcome to stay, have some food, and discuss, amongst yourselves, I guess. So I'll hand it over to Jocelyn, and we'll start it. Thank you.
And thank you, Michelle, and the Human Rights Commission for having me here today. I'm really happy to be here. I'm glad to have such a great turnout. I'm trying not to let my public speaking fear get the best of me. That's another reason I'm so glad you're all here, because I hope you can all participate and take some of the heat off of me. But anyway, so yeah, we're doing these presentations throughout Southern Minnesota, and really our kind of theme is know your rights. That's really the theme that we came up with, and so we're a bunch of lawyers, and so we did different topics of areas of legal rights that we wanted to be able to inform the public about. So some of the areas that I have information about, if none of you had any questions, I could sit here and speak for 30 minutes straight, but I'm not going to do that tonight. What I'm going to do is kind of tell you the areas that I have some information on, and you can ask me questions about them if you want. You can ask me questions about other things, and I'll try to answer if I know it. And if I don't know it, I'll give you my lawyer response that I don't know, it depends. But again, I want this to be a community conversation, so I'll just give you kind of an overview, tell you about the topics, and we can just start talking then. So in general, I'm going to give you an overview of the First Amendment in speech in public versus private areas, talk a little bit about the Human Rights Act and what that protects. Other areas that I have information about are schools and bullying, speech rights in schools, online and social media speech, workplace rights, English as a second language or non-English speakers and the rights that they have, and housing rights, knowing your rights in housing areas. And I also have knowledge about some of the remedies and actions you can take if you feel like you've been discriminated against. And so just as a starter, there's this thing called the Constitution. And the First Amendment and the 14th Amendment, we have rights as citizens. And so actions by the government, as you know, including actions by individuals who work or working for a governmental entity, including, for example, teachers in a public school or university, are subject to the Constitution and its limitations. The First Amendment prohibits the government from suppressing free speech or religious practice. It also prohibits the establishment of religion. And that means that a government can't make policies that favor a particular religion or favor religious practice over a non-religious practice. People cannot be deprived of life, liberty, or the pursuit or property by the government without notice and an opportunity to be heard. We're also entitled to equal protection under the law. And so the government cannot treat people unequally unless there's a good reason to do so. So in general, speech, whether or not speech is protected and to the extent it's protected depends upon where you're doing that speech. If you are on private property, there's really no protection per se by the federal government. Somebody on their own property can really say whatever they want as long as they're not inciting riots. If it's a public forum, that's a different story. That's where the First Amendment protections fall. And so, and then there is a limited public forum area, which would be places that have some need for, they still have governmental interactions, but it really depends on, if the government's going to allow somebody to speak in this area, they have to apply the restrictions equally. I'm not going to get into the nitty-gritty of all of that at this moment. There is something called the Human Rights Act in Minnesota, and your city is lovely enough to have a commission, as does Winona. I'm actually on the Winona Human Rights Commission, just as a side. And so the Minnesota Human Rights Act, I did have a flyer up on that desk. There is probably not enough for everyone, but it protects individuals in different areas such as employment, housing, public accommodations, public service, education, credit, and business. So credit protections, business protections. And so it protects certain classes of people, class based on race, color, creed, religion, national origin, sex, marital status, disability, public assistance, some of age under some of these categories, sexual orientation, and so those are areas that are going to have the fullest protection under Minnesota, the Human Rights Act of Minnesota. So there are certain other areas that people can get protections under, and again, there is a handout up there if you're interested. So I've told you a little bit about the areas that I have some information and knowledge about. I don't pretend to be the expert on all of these areas, and we could probably spend at least an hour on all of them if we really wanted to. But you're all here, and you're here for a reason. So just as a kind of, just a show of hands, how many people here have witnessed offensive speech or behavior in their lives? Yeah, not surprising. Does anybody want to give an example of that without naming names? Yes, ma'am.
I'll be happy to. Can I give you this just to make sure that everything okay. Yeah, I was told to leave the room at a city council meeting, with the joint meeting with the St. Croix Falls and the Taylors Falls city councils. And it was public comment period, and I was asking a question quietly, but it was a topic that the mayor didn't want brought up, and he ended up being a felon. And so, but I was told to leave, and he told the officer in the room to arrest me, and we're standing there, you know, he's holding my hands, and the crowd started screaming, and they did let go. But that kind of speech is something that, you know, is necessary and was limited.
And you, I'm guessing you felt discriminated against in that situation as well.
Well, threatened and on the verge of arrest.
Yeah.
I mean, but,
right.
And that's the kind of thing that we need to have. We have to have that speech allowed in this society.
Yes.
And I'm an attorney. I was representing a client at the time.
Yeah. Wow. Anybody in this room believe they've been discriminated against during their lifetime based on sex, race, religion, anything? Many of us. All right. Does anybody want to give an example? Don't feel like you have to. I could name many, but I won't. All right. So, what question? You're all here, and maybe it's just to hear me talk, but what are some of the things that you want to learn about or talk about today?
Defamation and public figure and that line.
Okay, I have some defamation knowledge, not a law school book's worth. Sir?
And Jamie's got a microphone, maybe we just want to walk it around so that people share.
I think there's a very interesting and important discussion going on in this country, at least it interests me a lot, between offensive speech that should be suppressed because it's harmful to others versus one's legal right to free expression. And I don't know what the answers are, but I hear convincing arguments on both sides of that. The ACLU, for example, would tend to opt for a broad free speech definition, including like marching down the street with swastikas and so on. But I really would be helpful to me to hear some more discussion of that, because I don't know what the answer is in my own mind.
Sure, I think that's a really very topical and absolutely important, and I have some information, but I don't have all the answers either. Yes, ma'am.
I had a follow-up question to that. Just what is the difference between hate speech and our protections for free speech?
Yes, so the difference between hate speech and regular speech. And I'm just going to jump into that, and I do think those two are related. I will discuss defamation, definitely. And I am going to reference this book here from time to time because I'm a little nervous in front of all of you, I just have to say. So hate speech in particular is not protected by the Constitution. This week, the Minnesota Supreme Court issued an, I wish I would have read that better. There was an interesting opinion that came out relating to hate speech, and I don't have enough knowledge about it. I can't, I wish I would have read that in depth. Erwin Chemerinsky, who's a constitutional law scholar, has this quote from an article out of a newspaper publication. There's no right to engage in violence. And he's speaking here about specifically university campuses. Campuses can take steps to prevent violence, such as preventing weapons at demonstrations, having speakers be in areas where safety can be assured, and moving counter demonstrations to another area. If speech is a true threat, causing a person to reasonably fear imminent physical harm is not protected by the First Amendment. So that right there is not protected speech. The classic example is yelling fire in a crowded movie theater. That's something meant to incite panic and fear, and that's something that arguably could be charged as a crime. Swastikas marching down the street are very offensive to many, many people, but it's also a First Amendment right to protest, to demonstrate. What is the proper remedy to that offensive speech? I don't have all the answers. Some answers are counter speech, counter demonstrations, and I think that's a nonviolent remedy. And again, like as was stated in this quote, you can limit speech, but it has to be under the right conditions. It has to be for the right reasons, for safety. You have to have a reasonable, and you have to be applying it the same based on viewpoint. That's a major constitutional area that's an area that the courts look at. So you can't allow somebody who is pro-life to have a booth at an event, but not pro-choice. That's a viewpoint discrimination. So that, if you're like a college setting, if you're a governmental entity or a public forum, that would be a distinction that's against the Constitution, or it's not constitutionally protected. And essentially, you know, a lot of campuses have, you know, they don't want people that are speaking hateful things on their campuses. The problem is that they can open themselves up to lawsuits by these groups or individuals if they deny them access to the university, mainly because they're getting government money. The colleges and universities, their federal laws, Title IX, Title VI, there are certain federal laws. When you get federal funding, you're subject to these requirements that you treat people fairly and equally. Yes?
Isn't one of the conditions to this the group, as far as allowing certain groups in? Isn't that relative to who's putting on the event? If it's a private event versus a public event, if you have a group that's putting it on for their members, there's not a requirement to allow equal access, whereas if it's a public event open to the public, then you have to.
That's a good question. So the question was, you know, does it matter if it's a private event versus a public event? I'm going to hedge and say I'm not exactly 100% sure, but I do believe that that would fall in, you know, if you're on private property, it's a private club, you can say it's your property. You can do that.
My question was, if it's public property, but an event sponsored by a private group, doesn't the private group then control versus public property?
Yeah. That one I'm going to defer to one of our city attorneys here.
So my name is Liz Vera. I'm an attorney who works with the city through the city attorney's office. So I'm not here to give legal advice to any one person or group, but I can comment generally. A large part of my practice area does involve the First Amendment with cities and schools. So what the question is asking is if the city or if a governmental entity rents out a private space to a group, whether that group can exclude other members of the public from attending. And generally the answer is yes, depending on the conditions that the governmental entity would place on the space. So if you have the exclusive right to use space for a certain time period or during a certain event or something like that, other people can be excluded based on the terms of, it's usually a lease or a contractual agreement. But if you, and that's true of public spaces as well, like a public park, if you get the proper permits and the permission to use it exclusively. But what it doesn't extend to is, for example, if somebody had rented out this room for an event and somebody wanted to protest on the sidewalk outside, generally that type of expressive behavior outside the venue would be protected. Does that answer your question?
Yeah, and I believe you could not be specific and just, if you allowed outside people, you can't allow all groups except this little group because you don't like this little group.
So it depends on the way that the city categorizes its facilities. So if a governmental entity allows access to facilities for, and some of them have, particularly school districts have various tiers where they say, we give priority to school groups, then we give priority to nonprofits, then we give priority to public groups in our community, then we give priority to other public groups. But what a public entity can't do is say, within those tiers, say if we have two nonprofit groups who want to use the state base, a public entity can't say, we're going to allow this nonprofit group because we agree with their speech and not this other nonprofit group. So that goes to the viewpoint discrimination that Jocelyn was describing earlier.
But wasn't the question about speech within a public place that was rented to someone privately? I thought that was what the question was about.
That was the initial question.
Yes, thank you, and that was, yeah,
The
that's.
follow-up question to that one, or just statement really, was it's a private group. I can invite just my group if I want to, but if I decide I'm going to let all males come in that are not part of this group, I can't do that and exclude women.
Right, but the question was, which hasn't been answered, I don't think, was what about, say you want to invite someone into your private group, but they're spouting hate speech in a private group in a public setting, public building? That was the original question.
I think that the hate speech adds a different element to that, because I think that hate speech, since it can be regulated constitutionally, would create the twist on that scenario that allows some regulation that wouldn't otherwise be prohibited. I expect, based on most of the contracts for use of spaces that I've seen, that the space has to be used in a otherwise lawful manner that would limit some sorts of the extreme forms of discrimination or extreme displays that might otherwise come up.
Liz gave a much better answer to that question than I would have. So, anybody else? Any other comments? Yes, sir.
What about the authority? Who has the authority to make the decision on whether it's lawful or not? Let's take a real example, because we're talking about law.
Yes.
We're assuming a lot of things. Let's say that something happens in the city council meeting. Who is the one that makes the decision, and what can and cannot be said? I mean, that's really broad there, but who is the minder of the rules?
So my thought. So the question, I believe, is for example, a city council meeting, who makes the decision about whether or not speech is allowed or not, or
if the rules are being broken?
Oh, if the rules are being broken. Good question. I'm going to say that most municipalities are going to have rules and regulations and policies, and they're going to look to those first. They wouldn't be able to have a policy, and they have to, the key is applying them consistently and uniformly. You can't really, it's my opinion at least, and that's going to be my de facto, and this is all really my opinion, and I may not be 100% right on all of it, but I believe that if you're saying this person can only talk for 2 minutes, but everybody else gets 5, that's a clear violation. If there's a policy about, or if it's a meeting that's tight time, there's a certain time frame, and there's a full agenda, and the policy is we're going to limit all public comments to 2 minutes, 5 minutes, 10 minutes. I think that's pretty uniformly allowable because
How can that be enforced? I'm sorry. I'm looking for the resolution of this because it happens sometimes, and it happens so quickly that it becomes a crisis mode. And here we are always responding to crises instead of planning ahead. Can you plan ahead on this? Or how do you respond to it if you can't?
Sure. What do you all think? Yes, ma'am.
Well, here in Red Wing, it's the council president that's in charge of the meeting, and ultimately they would be the one to decide. The city attorney would be best, I think, able to answer that, but they are in charge of the meeting, controlling it, and that would be their call.
So one of the ways that speech can be regulated is what's called reasonable time, place, and manner restrictions. And that's essentially restrictions that are put in place to be uniform, that allow things like public business to be done. So something like a city council meeting or a commission meeting is a place where certain business has to transact. So as important as it is to have public input, it's also important that the council members are able to hear the members of the public, and that all members of the public who want to speak have an opportunity to participate. So I believe you use 3 minutes here for public comment. So it is the council president who has the option to, or who has the determination of whether someone has violated that time limit. It's also, the council president has discretion to determine whether a topic is germane or not. So during an open discussion period, the public comment period, certainly comments on any topic is relevant. But during other times, like a public hearing on a specific item that is coming before council, the council president would have the right to issue essentially a manner restriction that would say, you know, discussing the tax assessment on this parcel is not the time that we're going to discuss the road conditions on Highway 61 or something like that. That in order to keep the council's business moving forward, those time, place, and manner restrictions can be put into place. I think this council has been, at least to my knowledge, attempting to discuss the rules and trying to determine how best to enforce them. But one of the problems that I do think arises in a lot of different public bodies that I work with are that it's hard to determine ahead of time how you would deal with those situations because each one that arises is a little bit different. So, you know, certainly it's easy to say your time has expired, please sit down, your time has expired. But how people react to that, whether they choose to continue speaking, whether they decide to get loud or that upsets other people in the audience are all variables that happen. And this isn't just a Red Wing problem, it happens with a lot of my clients. But how people react is something that can't ultimately be planned for.
And I would just add, just a moment, I think a good not the best solution maybe, but a good solution to that maybe, if there's an area where there's a lot of interest, open it up for public comment via writing or, and have a time period within saying, you know, wow, there's a lot of people here. We don't have time for it all. We're gonna give you 7 days or 14 days or something to that effect. And we will, as a council, review all these comments. I mean, I would, to me, that's a reasonable attempt to accommodate everybody. Certainly you're losing some of the getting your view out to the rest of the public, but it's one option. Or posting those public comments for viewing might be a remedy to that. Yes, sir, you had a question.
Yeah, I do. And I think probably anybody who's been a working activist has probably could tell anecdotes about situations where they've been asked to shut up or to sit down or to put their sign away or to leave or whatever, and they're not sure what their rights are. But let me ask about a specific situation that one runs into. Let's suppose that I'm a state agency holding a hearing on a permit, and they could hold it, and it's legally required probably, and it may have evidentiary significance, and there's maybe more or less procedural structure to it, but that event could be held, say, in the Red Wing City Council chamber, which is clearly a public space, or it could be held in the St. James Hotel, which is presumably a private space. What are the differences, if any, in what rights people have in those two different situations?
I would say that there isn't a difference because it's still a public meeting. It's required, and so it's a government meeting. It's free, you know, speech. First Amendment applies fully, and so, you know, any normal policies or regulations that are in place for that area would apply. And I would hope that, you know, they would do it somewhere where you can accommodate the interest, the public interest. So, yes, sir. She's gonna bring you the microphone.
Not trying to divert from the public meeting venue, but a word that seems to be coming up more and more as an effort to limit expression is not just among children, but among adults now, is bullying. And I'm seeing that being used increasingly. And is there any legal definition to that term at this point?
Legal definition to bullying, I think Minnesota just passed, did they just, or how long?
3 or 4 years.
I'm gonna let Liz take this because she knows the answer.
So another one of my practice areas is school districts. So we had a lot of work put in a few years ago when Minnesota adopted a law prohibiting bullying. So there is a statewide definition for bullying that applies in Minnesota. The basic elements of it, it's about half a page long, so I'm not going to recite it. But the basic elements require that there be some sort of power differential between one student and the student who is being bullied. So that can be a social status issue, or that can be a perceived race issue, or an older student to a younger student, but some sort of perceived power imbalance that also has an element of unwanted or negative comments or physical behaviors toward the student. There's also, it's not required, but the bullying statute does incorporate a lot of the same protected classes that Jocelyn described in the Minnesota Human Rights Act, including things like race, gender expression, are all categories for which students are prohibited from, you can't target a student for bullying because of those. I will tell you that the bullying statute itself does not have a whole lot of teeth. And a lot of it is coming down to how schools are enforcing or adopting policies that implement it, and that varies a lot depending on the school district and school cultures across the state.
I guess my question, maybe I didn't make myself clear, my question was aimed at adults, because that word is being used now in an effort to control adult conversation, and what would be the protections against the overuse of that word?
So the gentleman's comment is the use of the word bullying to essentially stifle conversation, First Amendment speech rights. And I think that's very interesting. I think it's true. And professionally, I think one thing that people can do, if they feel that they are being, I'm gonna rephrase it and not use bully, but I'm gonna say harassed. If you feel like you're being harassed, there is a remedy, a legal remedy in Minnesota called a harassment restraining order. And so that would, if somebody is targeting you and giving you, the definition is repeated intrusive unwanted acts or gestures that have basically a negative impact on your safety, security, or privacy. So if somebody is harassing you on, if somebody is, I shouldn't use the word in my definition, in my example, but so if somebody is bothering you over and over on Facebook, and you say, stop it, you're bothering me, I don't like this, and they continue to do it, that there may be the basis to get yourself an order against that person to stop them from having contact with you. I'm not going to say it's always going to work, because it's a very fact-specific scenario. Somebody can also get a harassment restraining order if they've been the victim of a sexual assault. And harassment order, you don't have to have any certain type of relationship with this individual. It just has to be repeated unwanted acts or gestures. And so that is a remedy. It's a civil order, but the reality is if somebody violates it, they can be criminally charged. And if you violate it multiple times, you can eventually get charged with a felony. So that, I don't know if that answered your question.
I was just thinking from the standpoint of perhaps somebody has a conversation site or something, and perhaps you can get the sense that they want to control what's being said. They don't want to maybe open up to a fair amount of conversation, or they don't want to hear things that they don't want to hear. And so they might say, well, you're bullying, that's bullying conversation then, and they could remove you, they could, that sort of thing. What is the protection of, somebody who wants to stand up and say, well, I disagree with you, and then being called a bully?
I think that's absolutely correct, and there's no perfect answer to that. it's the reality of the social media world we live in. Almost all, if not all of these sites have user policies, and so one of the things you can do if you feel like somebody is posting offensive things on those sites is flag the comment or report it, and they are apparently have people actually review it and then decide whether or not it's actually offensive. They also do that with pornography, I believe, on those sites. So could
What's
some
the definition of offensive?
that would probably, what's the definition of offensive was the question, and I
I
would.
know what mine is.
Yeah, I mean, true. I mean, what's offensive to one is not to the other, and that is very fair. And I would
Sorry.
yeah, that's okay. I think I would almost say it's a case-by-case basis, but it's also likely defined in the user policies of these online venues. And so I don't think there's a great answer to that problem, because, I mean, really in our whole society though, people hear what they want to hear, or they accept they're more likely to accept things that they agree with as true than things that they disagree with. I think in general, that's not always the case, but yes, ma'am.
So to that point,
Yes.
because people like to accept and hear what they agree with and disagree with the things that are less agreeable to them, when you're in a public situation and we're having challenges with people being heard, wanting to have their say, rules and regulations, who gets to decide, then it does mean that we need to step back a little bit and, it's not a check of privilege, but it's check out what is your line on what you're agreeing and disagreeing with on, and where are you deciding that someone's broken the rules and not broken the rules, because that's all based on your own personal opinion and beliefs and values. But, as we always like to say, there's like 3 mirrors. There's my opinion of you, there's your opinion of me, and there's the little mirror over here watching the whole thing. And so it seems to me like we need to take even an additional step to be careful that we're not just going from my opinion and your opinion, but we're standing out here and being just a little more fair and open to the situation.
I think that's absolutely true. And I think that this isn't the answer, but trying to have these things in the policies can help guide. And if it does come down to that council person's, the head's decision, and there isn't something clearly written, I would like to think that if things are happening too frequently that are disagreed with, then ultimately when re-election time comes, that and I don't live in this community, and this is not meant to be towards this town, but the voters can then decide whether or not these people are acting appropriately or not. So yeah. Yes, sir.
I think we merged actual bullying with cyberbullying a little bit earlier. This is just my opinion. I personally think that cyberbullying doesn't exist, and I would like your opinion on that, because people could just log off or close your eyes mentally and just pass that comment. That's just my opinion, but I would like to know your input.
I think there is some personally, I think there's some real cyberbullying, but I think there's a lot of, I do believe there's bots, and that's just me. But I think that a lot of this, we should be trying to find what unites us instead of what divides us in society. And there's so much polarization on issues that I would like to try to ignore the bullying. If I see a post, or if I'm on Facebook and I see a post with a lot of comments, I personally just try to, I'll read the information and take it for what it is, but I'm not going to take that comment as true or false. I think there is a real danger when you're dealing with children, though, because kids, you know, they're not adults, and they are very sensitive and have developing brains and minds, and you know, there's a lot of kids out there that take their lives because of that, and I literally read 2 in the paper last week that, not in this area, but it makes me really just sad, very sad. Yes, sir.
So what's the distinction between a public space and the internet as far as bullying? If I see somebody bullying somebody at Walmart, not because they're Muslim or gay, but they're wearing fur Packers jackets. And it may not be at all physical, but it's confrontive. And what's the difference between bullying somebody in real space and bullying them on the internet?
The question is, what is the difference between bullying somebody in person and bullying someone on the internet? I mean...
Legally.
Legally?
Sorry.
No, well, that's a hard question.
Yeah,
On the internet, you've got documentation. In
Yes.
person, you don't have.
I think really it would matter if somebody's committed a crime or not. If you've assaulted that person, if you've hit them or caused them physical harm, or fear that you're going to hit them, that's the definition.
That's called assault.
Assault, yes, so that's a crime.
What about goading them into suicide?
Goading someone into suicide? Oh gosh, I don't know if I want to go there.
Sorry.
No, I do think that's really important. But
we have seen some of those cases start to emerge from schools where students were bullied for one reason or another and ended up taking their lives, and the parents have sued. When I get involved is when they sue the school district, alleging that the school district should have stopped the bullying. And it's relatively new, so those cases haven't reached conclusions, and it's so I will say it's an expanding area of law. It's not one we have a lot of answers in yet. I certainly come at that from a perspective of somebody who defends schools in those cases, but I understand that it's a very difficult situation for parents to be in. And I think that's one of the reasons that Minnesota has taken the firm stand on passing the bullying law and trying to address bullying. And the bullying law in Minnesota actually does include cyberbullying. So it includes speech that's made off campus if it's directed toward a student and has a direct and substantial relationship to the school environment. So that can include a Facebook message if those students see each other every day at school, or it references something that happens at school. So that's, I think, one of the ways that they're trying to at least use the law to define those connections, but we don't have a lot of clear answers yet.
Right. What about being snarky or sarcastic? I've known of a few school students that, you know what I mean? Or picking on them, like, seriously, for wearing fur, Packers jacket, something that doesn't discriminate against them other than that they're stupid or a wimp or something like that.
The question was kind of where's the line between being like making stupid or snarky comments about like a student who wears a Packers jacket versus statements that cross the line into bullying. And I do think that's a really tough call for administrators and teachers to make on a case-by-case basis. A lot can depend on the context and the relationship between those two students. So yeah, that's a hard one for me to sit here and say, you know, you can make fun of a Packers jacket but not their haircut or something like that. But I think that that's where the courts, you know, from my experience, would look at that on a fact-intensive level and say, you know, was this consistent? Was it something that the kid knew bothered the other kid, or things like that, to determine whether it was really bullying or if it was just kind of classic, you know.
So I can't bother someone according to the law?
See, and I think that.
I'm not trying to give you a hard time.
No, and I don't know if I should admit this, I was a sarcastic kid too, so I have some sympathy for that. But I think that the courts and hopefully administrators as well, would take that into consideration of whether it's good-natured ribbing between two friends or the type of person who can kind of take that level of joke versus someone who is discriminating against someone who is obviously in a different position and not able to understand the nature of the joke.
And I'm going to piggyback off of that because Liz has sparked me to the case I was thinking of earlier. It was upholding a conviction against a juvenile for it was a criminal conviction relating to essentially harassing a autistic child through Twitter, or not Twitter, or one of the platforms that I'm not on. And this person had put a bunch of statements, really, I guess, bullying, teasing this child, and the parent got a harassment order again on behalf of this child, and somehow there were criminal charges involved, and it was challenged on constitutional grounds. And so the Minnesota State Supreme Court said, nope, this statute is just peachy keen as far as First Amendment goes. It's not vague, it's not overbroad, it's specific enough in what it is saying. And I'm sorry I don't have a case cite.
What about nerds?
Are nerds protected?
Yeah.
Right behind you, you know.
I would think everyone's protected, but I think it really is, it's very fact specific, and I'm sorry to give you that. That's really how a lot of these situations go.
And I was captain of the debate team, so I'm going to say yes.
And I want to answer your question as best I can, which was about defamation and
public figures.
And public figures. Okay. I'm going to ask you if you can try to paraphrase it for me again.
It's about like responsibility of speech and what is the boundary where you get into defamation, and then what about public figures? It's like with rights come responsibilities.
Sure,
so
sure.
What are the responsibilities?
In general, a public figure has less protection for less ability to seek cases based on defamation because they've put themselves out there, whether almost always intentionally. I think there may be an exception for children, but an elected official is a public figure, and in order to show defamation, oh gosh, you're gonna make me read here.
This is a test.
So you have to, in order to, the person seeking to get relief for their defamation, which is a civil suit, by the way, you have to prove the statement was false, it was communicated to someone besides the plaintiff, and that it tended to harm the plaintiff's reputation and lower him in the estimation of the community. So in effect, per se, if it affects the person's trade, business, profession, office, or calling, it's defamation. But again, and then you can get damages, but really, if you've put yourself out there at public, if you're a celebrity, elected official, it's a lot harder to win a case like that, and I don't know the exact line.
It has to be intentionally false or reckless.
Thank you. All right, and yes, you have a question.
In the setting of a public meeting, so back to public meetings, if you are speaking at city council, or you're in the audience at city council, what constitutes a distraction, a disruption, and disorderly conduct? Like, where are those definitions, and where do you cross the line? In regards to also passive protesting, if you want to throw that in the mix, in case you're not stumped enough.
Well, I will say, it depends. Sorry. But I can tell you that Minnesota has a disorderly conduct statute. It was part of one of the subsections of that was struck down by the state Supreme Court in the last 6 months or so in a criminal case. Hensel, State v. Hensel, Hensel. And so the part that was disorderly conduct, if you disturb an assembly or meeting, not unlawful in its character, was struck down. It was overbroad, it was vague. I don't know that I know the answer to that question. I think that in Hensel, it was a woman who had a large sign and was blocking some of the views of people at the meeting. I don't think she was swearing. I can't tell you the exact answer to that, I'm sorry, but I think that's a great question. What do you all think would be offensive or disturbing and enough to get somebody thrown off to jail or charged with disorderly conduct?
I just want to comment, and Robin Hensel is a friend of mine. I'm a great admirer of hers. But I think the key point is that freedom of speech is maintained at the margins. It's maintained by people like Robin who have a commitment to go through the hassle of civil and criminal prosecutions. And Robin, I wasn't there, but I have a very clear sense of it that Little Falls, Minnesota is a very reactionary place, and they didn't like what she had to say. And they hate what she had to say, and maybe they hate her, and they wanted to shut her up. So everyone, indebted to her for making the effort to insist on her right to have her say. And that's my speech.
Thank you. Yes, sir.
That's to my point that I asked before. Who's in charge of saying yes or no in a group? Because we're always reacting to this, and so I mean, it's nice to hear that you're confused sometimes, but it's also that all the people that are involved are also very confused to this because it's not clearly put out there. And yes, you can't do this, and no, you can't do that. But I mean, who's going to make the decision? And I think it's the council president, I think, was the answer.
And I think being as clear and, what's the word? Putting it all out on the table, laying out your thought process is the best thing you can do in those situations. Here's why, explaining yourself. And I'm coming at that not from somebody who would represent, a municipality or anything, but just, in my mind, that's what I would want to see. Why did you make this decision? Can you spell it out for me? So that I can understand, and then I can either agree with it or not. Yes, sir.
To a certain extent, I disagree with Liz that says you can't anticipate. I think you have to anticipate. And if you're the council president, if you've got clear policies and you've studied them so that you know your business, I think we get in trouble when we have incompetent leaders making decisions off the cuff and, So, and if I'm in a meeting where there's a hot issue and I'm going to have public speakers, I would take preemptive action and say, okay, folks, here are the rules. And I want you to understand the rules before we start. So that when you shut them up because they've gone for 2.5 minutes instead of 2, it's clear to everybody why you're doing that. So be prepared.
I would agree. I would agree. I mean.
And you're always going to need an arbiter.
Yes.
Well, it's idealistic to think that two people are going to be civil to each other on something on which they disagree.
It's true. But I think being clear and applying it consistently and fair. I mean, and fairly, although the definition of that could vary as well. So, I mean, what's fair to one isn't fair to the other. But yeah. All right.
Are there
other
any quick
questions? Comments? Yes, sir.
Well, I've already spoken, maybe somebody else wants to.
Does passive protesting fall under disorderly conduct?
Give me an example of what you mean.
A sit-in, where if someone decided to sit in at a city council meeting and just sit on the floor and not say anything, could they be removed forcibly? Or, because it's not really disorderly, there's no threat, there's no noise, there's no disruption, the meeting can continue. So is that disorderly conduct?
In my opinion, I don't think so. And I do have I had some defense background, so I would say that's something that I would say no, but you know, other people, really, I don't think so.
Do you think that if city council thought it was, that they would have a very expensive lawsuit on their hands trying to fight that?
I don't know.
What were the entities' policies about what constitutes disorderly conduct? That's where you have to have clarity of policy.
Yes.
I can't answer that question in the abstract.
So we have 30 more seconds, just because I want to be really good with your time, and then you are more than welcome to stay after, because I see hands, and you hate to stop a meeting, and it's really
For
fun.
the,
Yes, go ahead, sir.
oh,
I'm sorry.
I guess for the sake of the people of the city of Red Wing, for the Red Wing City Council, everybody involved, consistency then would be very important, so that being a small community, it might be easy to want to let somebody speak more than the allotted amount of time, but perhaps if everybody started policing, including the city council, literally started, began stopping people when they reached that point, that sort of consistency might actually be to their favor at some point at which they need to cut the line, or cut somebody off for I don't know, offensive behavior.
Absolutely. I absolutely think that. I agree with that.
I don't know why I'm possessed of the desire to say this, but I am, that communication requires both a transmitter and a receiver. And we're talking here essentially about the right to say things. But the other side of the equation is that there to be a sufficient intellectual aperture that people are capable of hearing what's being said. And my observation of this community is that there are areas in which it is trying to learn how to hear better. It's trying to learn how to listen. It's trying to recognize that, for example, that the experience of people of color in dealing with police may be fundamentally different from those of us white males. On the other hand, there are issues in which the community has no desire to learn how to listen. If I run my mouth about Xcel Energy or about garbage incineration, you can see minds closing like a trapdoor with a big spring. So, I think that the community is making progress, and I think what you said tonight is helpful, but I do think it has a long way to go.
Thank you, sir. And I think it is encouraging, and I know we're getting done, that, if people can talk to each other and see each other as people, you don't have to agree on every issue, but if you are able to talk and have rational conversations on some issues, get to know that somebody else as a person and not just somebody who has a different viewpoint, it makes the ability to at least try to talk and listen to each other a little bit easier down the road. And that's my thought on that. So.
And I would like to thank you, because I do believe this was an example of civil discourse. We had some tremendous questions, we had some excellent participation, and we challenged the issues. And we are trying to learn. I mean, we're talking about cases where the Minnesota Supreme Court hasn't made decisions yet. So we're obviously pushing the limits of what it means for free speech and disruptive behavior and all that stuff in the state of Minnesota and within the community of Red Wing. And part of the reason we had this workshop tonight was so that we, as members of the Human Rights Commission, could get input on our decision making. Because we are going to be providing guidelines to present to the city council for them to consider in enacting a legislation for whatever, ordinance, some legal thing to do with what constitutes disruptive behavior and such as that. We want information, and then we were trying to learn. And that's exactly what we're here. And I would like to thank all of you for participating. I thought this was an excellent, excellent evening. And if you want to stick around and learn some more, talk some more, please do so in the same courteous manner. Thank you.